Good afternoon, everyone, and thank you for joining us today. I'm Tom Deely, a senior associate at Howard Kennedy. I'm joined by Alex Giles, my colleague, and James Poole, counsel from Tenall Square. Today, we're going to be discussing the use and effect of no contest clauses. Most of us are familiar with the concept of a no contest clause. They appear within most will precedents and were clearly seen as an interesting plot feature by Victorian novelists, and clauses preventing a beneficiary from inheriting in the event that they remarry appear in works by George Eliot and Charles Dickens, amongst others. However, despite the best efforts of Dickens and Eliot, no contest clauses do not appear to be a topic that generates huge amounts of interest and are not regular headline hitters in the Daily Mail. There's a place for such clauses in fiction, but do they serve a purpose in mitigating against claims? There is relatively little case law on no contest clauses, but in light of the prevalence of claims against the states under the Inheritance Act, it's about time to bring these clauses back into the limelight. Our talk today will outline the use and effect of no contest clauses, relevant drafting considerations, and our best advice as to how and when to use them. In terms of the structure, I will be outlining the arguments that have been raised against no contest clauses being valid and the guidance from the High Court and Privy Council. James will be discussing the benefits of using no contest clauses, and Alex will highlight relevant drafting considerations before we put these all together in a working case example. What is a no contest clause? A no contest clause is a clause which can be included in a will to deter a beneficiary from bringing a challenge to the will, either in terms of questioning whether the will is valid or in bringing a claim against an estate, such as under the Inheritance Act. The case law that does exist demonstrates that no contest clauses have been a controversial topic over the years and have divided opinion as to their use and effect and their validity. Are they repugnant and contrary to public policy and therefore void, as has been argued? Or are they a valid and useful bastion to protect and uphold the principle of testamentary freedom and make wills great again? No contest clauses have always been capable of being included in wills, and the question as to whether a no contest clause was valid was put before the Privy Council in the case of Cook and Turner in 1846. The backdrop to this case is quite interesting because Sir Gregory Turner was declared a lunatic in 1826 by a jury, and he subsequently made a will in 1841 in which he left the majority, but not the entirety of his estate to his daughter, Mrs. Friars. The will included a no contest clause specifically against Miss Friars, stating that if she were to challenge the will, she would lose her entitlement. And obviously in the context of Sir Gregory Turner being declared insane, you can see good reason why Mrs. Friars might have thought there were some concerns about the will being valid. Nevertheless, Sir Gregory Turner died without revoking his will, and following his death, Mrs. Friars did decide to challenge the will. So the question put before the Privy Council was whether her challenge activated this no contest clause and whether it was valid such that her entitlement was lost. Mrs. Friars argued that a condition which induces parties to abstain from contesting a will of a person who has been declared a lunatic and therefore insane is against the interests of the state and against the liberty of the law, and therefore must be void and contrary to public policy. The Privy Council did not agree with this view and indicated that Mrs. Friars was confusing the interests of the state with her own interests, and stated that it matters not to the state whether the land is enjoyed by the heir or the devisee. And we conceive, therefore, that the law leaves the parties to make just what contracts and what arrangements they may think expedient as to the raising or not raising questions of law or fact among one another, the sole result of which is to give the enjoyment of property to one claimant rather than another. So that was the first indication, or the earliest indication, that the contest clauses would not be void for being contrary to public policy. In terms of the chronology of no contest clauses and when and how they were used, that changed slightly with the implementation of the 1975 Act. And the leading case on cases of 1975 Act was the case of Nathan and Leonard.
Apologies, seem to having some issues.
We're having tech issues, sorry, moving to the second slide.
It's not coming up properly, is it?
Why don't I share my screen instead?
That
Sorry.
might be better. Sorry, it's just not
Sorry,
coming up.
I'll get that going. Keep talking. I'll bring that up in a sec.
So the position on no contest clauses in the context of a claim under the Inheritance Act is obviously very different, and the considerations for testators, for claimants, and for the court, it's completely different for all reasons. So again, there's little guidance from the court, but in 2003 there was the case of Nathan and Leonard. In this case, the testatrix owned 50% of a property in which she lived with her two friends, Sally and Paul Leonard. She made a codicil to her will in which she left a right to occupy the property to Sally and Paul Leonard, and the residuary estate of once they left the property, the estate was passing 2/3 to Sally and Paul Leonard, and the remaining third was to be held on discretionary trust for her son Andrew, his children, and two charities, one of which was Mind. She later made a second codicil in which she introduced a no contest clause, which stated that if Andrew challenged the will or challenged the dispositions, the entire estate would pass to Sally and Paul Leonard. So the outcome of Andrew challenging the will would mean that the other beneficiaries, i.e. his children and the two charities, would lose their entitlement. Sorry, we go to the previous clause. Previous slide, sorry. And on Miss Leonard's, on the testatrix's death, Andrew started to issue a 75 Act claim, which triggered the considerations as to the no contest clause being valid. Andrew himself was neutral as to whether the clause was valid or not, because he considered that the provision hadn't been made for him that was reasonable in any event. But the charities were obviously quite concerned with this, because the outcome of the clause being valid would invalidate their interest in the estate. So Mind, on behalf of the charities, took the issue, joined as a party to the claim, and disputed the clause being valid as a preliminary issue. And the High Court were required to consider a number of considerations about whether the clause itself was valid. And the arguments raised by Mind were that the clause was contrary to public policy, similar to Cook and Turner. In this instance, they argued that the clause purported to oust the jurisdiction of the court and to predetermine the issue, and therefore was contrary to public policy. The High Court disagreed and said there was no ouster. The purpose of a no contest clause is to deter, not debar a claim, and therefore a no contest clause is not void for public policy reasons. Mind also argued that it was void for repugnance. Now, I don't think they meant it was distasteful, but in this instance, they meant that the repugnance was that the clause itself, the impact of the clause, was to restrict the ability for the beneficiary to deal with the property that was gifted to them. The High Court didn't agree that this was a relevant consideration in this case, as a no contest clause doesn't restrict a beneficiary's dealings or ownership of the property. They attack the will as a whole. Mind also argued that it was void on the grounds of caprice, and the High Court disagreed. And just as a will is not void for caprice, nor is a no contest clause. A testator is allowed to be capricious. There were some useful guidance from the court in this case on the drafting considerations, and Alex is going to be going through these in more detail, so I'll skim over them now. But in terms of the validity and the need for a clause to be valid, it needs to have sufficient clarity on the gift over, which means that the clause itself must provide that the benefit that is being forfeited will pass to someone else. They must also have certainty, so they must be framed so that the persons affected know with certainty the outcome of what's going to happen if their interests are to be divested. The case also gave some very useful guidance on triggering events. The wording in this no contest clause from the testator in her codicil was, should they wish to contest or disagree with my will? And obviously, what does disagree with my will mean? Does it mean you see the will and you think, oh, I don't like that. It can't mean that. So it must mean more than that. And there must be a line in the sand as to when that kicks in, the triggering event. So the guidance from the court, and Alex will be going through this in more detail, was that unless the cause expressly makes very clear when that kicks in, the point will be on issue of proceedings. In this case, as discussed, the charities, of course, were liable to lose their entitlement in the estate because of Andrew's decision to issue proceedings, which would seem on its face manifestly unfair. And the court gave useful guidance that in such circumstances, a beneficiary who loses their entitlement through no fault of their own has the ability to apply for relief from forfeiture, and that will be considered on a case-by-case basis. Unfortunately, there hasn't been much subsequent or any subsequent case law to deal with guidance on that point, but the ability to apply for relief exists. I'm now going to pass over to James, who's going to discuss the benefits of using no contest clauses.
Perfect, thanks, Tom. I should say, just in terms of asking questions that we should have some time at the end, but there's a Q&A function as well. So if you do have questions we're going through, feel free to stick them on there and we'll try and answer them as we're going along. I'm also going to try and do this, I can see my notes, which may mean that this whole thing goes awry, but hopefully you can still see the screen. Tom, Alex, look all right?
Yeah.
Yeah.
Great. So I think when we were talking about this talk, what we're going to talk about, the reason we alighted on this topic, as Tom alluded to earlier, was is that when you speak to clients, or certainly I speak to clients, and just people at large in the world generally, people are pretty surprised when you tell them that if you can make a will and you can cut whoever you like out or give your money to one person or not to other people, and it doesn't really matter because there's this Act of Parliament, 75 Act, that means the court can effectively rewrite what your will says. Obviously, there are limits to that, and it's not completely unfettered. But obviously, the court has very broad discretion. 75 Act. And a lot of people find that pretty surprising because the fundamental principle of English testamentary law is testamentary freedom. And obviously, the 75 Act is a deliberate and in many respects a very important limit on that, and one that makes sure that people who are deserving do get provided for. But it is in some ways surprising that it exists, given the testamentary freedom. And I think what's happened in the last decade or so, both anecdotally, but just also stats bear it out. Firstly, the number of 75 Act claims has been rising for the best part of a decade. That's happened consistently. But particularly since the decision in Hirachand, there's been pretty rapid growth of what already sort of existed, with these sort of PI style 75 Act claims, where you find firms acting on CFAs racking up very significant costs very quickly. That's partly the impact of the way these are Part 8 claims, 75 claims, Part 8 claims, therefore they do require front loading of costs to some extent. But also, they'll say, we spent £40,000 writing 3 letters and £70,000 drafting a witness statement, and so our costs are £110,000, and we're on a CFA, so 100% CFA, so it's £220,000 before we get started. And what they do is they do that, and they get you to a mediation, and then they say, okay, well, it's £220,000 as the starting point. That's zero for our clients, so we need X. That has grown up pretty quickly in the last few years, partly as a result of the Hirachand decision, and it's a pretty problematic, I think, issue that's increasingly becoming a problem, and because it doesn't actually help the clients really very much at all in lots of cases. Because all you do is you call their bluff and you don't make any offers at all, and they abandon their clients after the mediation. The other thing that's happened is an increasing number of sort of what you might call ransom probate claims. It's not hard, especially if you have an elderly testator or a person who is terminally ill when they make their will, which is not unusual, that you can find examples in medical notes of confusion or uncertainty or medical diagnoses that could do that, or they're on medication that has side effects that cause confusion. There's lots of ways in which you can build a lack of capacity. Now, they may not be persuasive in terms of winning a trial, but there's enough there that creates an uncertainty that you can say, okay, well, we say the person lacked capacity when they made their will, and you may have the other parts of it as well, undue influence, lack of knowledge and approval, so on. And there's been, I think, a rise as well of these types of ransom claims where you say, this person clearly lacked capacity, and all you're really doing is saying what I've been given under the will is X, and what I want is a bit more than that. And so if you give me a bit more than that, I'll go away. So these I suppose are the issues that we identified that are in this sort of world at the moment. There are obviously lots of others as well. And I suppose the point is, or the point of this talk is to try to suggest that no contest clauses may be a pretty effective way of solving this. There's no panacea, but might actually help in lots of circumstances in preventing these types of claims. Why is that? Well, I think there are two reasons. The first, two linked reasons, I should say. The first is a pretty obvious one. It changes the analysis of risk on any claim. So if you are bringing a claim and that now includes a risk that what you have is going to be forfeited and you might end up doing worse than what you already have, that completely changes your analysis and when deciding whether to bring that claim or not, or challenge the will or not. So, where you often start from a position where, let's say there was a state was £1 million and you've given 100,000, you start off saying, I've got 100 grand, that's in the bank, and that's also secure from in terms of paying costs, paying my solicitor's fees and so on. But I want more than that. That's fine in a normal claim, but where there's a no contest clause, what you're actually doing is putting all of that at risk. And that completely changes then your analysis. Now, obviously, if you've been given a fiver in £1 million estate, there's no real risk at all, giving up nothing. But if you've been given quite a lot of money and actually there's a chance you might not do better than that, or you might do similarly to that, then actually that completely changes the risk analysis in deciding whether to bring a claim or not. In order to make that actually worthwhile, and particularly in the context of 75 Act claims rather than probate challenges, which are obviously binary in outcome, the will is valid or the will is not valid. But in the 75 Act claim, where there's a range of potential outcomes for any claimant, and it's very hard to say with any certainty that someone will get this or that. Generally speaking, you advise and say you could get somewhere between X and Y. In order to try and in order to make no contest clauses effective to put off those kinds of claims, really what I think you need to do beforehand is ensure that the provision is at least semi-reasonable. So that really requires, it's not an easy job, but requires, if you're advising a testator or a testatrix, is to think about what their estate is, who might potentially bring a claim against their estate under the 75 Act, and what they might get on such a claim, or what the range of their outcomes might be, and then make provision that's somewhere within that range of outcomes, perhaps right at the bottom end of it, but at least then someone who's then later the beneficiary, disappointed beneficiary, when they're thinking about it, well, having been given something, they will take advice, and the advice might say you can get to an X and Y. If what they've been given is within that parameter, it's going to be a very risky claim for them to bring, which means obviously it's less likely they will bring it. Now, of course, it could be said that in bringing that claim, you're effectively strengthening your claim, because if you've been given that £100,000 and now you've got nothing because you brought a probate challenge or you brought a 75 Act claim, you're doing better. Now, that of course is, especially in the context of 75 Act claims, correct, but it only goes so far, that kind of analysis. I mean, the reality is that a judge looking at a claim will of course have regard to what the claimant was given under the will and what they've chosen to give up by bringing the claim. And any defendant defending that claim will raise it in all the circumstances, always part of the defendant, but also as part of the claimant's conduct, to say that effectively the claimant could have had X and actually they're going to get less than that because they're claiming rubbish, and make a whole sort of hoo-ha about why that is actually bad conduct on the part of the claimant to give up a perfectly legitimate entitlement. Linked to that, and this is the second reason why these no contest clauses can be useful, is costs, particularly again in the context of 75 Act claims, because if the outcome of the claim is less than or broadly equal to the provision in the will, and that also taking into account unrecoverable costs and things like that, then it really puts the claimant at quite a serious risk on costs. Because if you've given up £100,000 to get given 110, I think there's a very legitimate argument to say that actually you've lost overall, because while you might have got 10,000 more on the face of it, your unrecoverable costs are going to be greater than that, and the trouble and time and stress and so on, just to get £10,000. There's going to be a strong argument that you're not going to be entitled to your costs, and certainly that the defendant shouldn't be paying them. And then obviously that becomes even more clear if you don't meet what you were given, because effectively it's almost like having an offer on the table and not beating it. You could have taken that money, you chose not to, and you've actually chosen to bring a claim and got worse an outcome. So that's another good reason why these kind of clauses, if properly drafted, and obviously if you make proper provision for someone, can be a very good way of defeating claims before they ever begin. So on that topic, in terms of how to draft them, I'll pass it to Alex, who's going to talk about that.
Yeah, and would you mind skipping across to the next slide? So I'm going to go back to Nathan and Leonard, and this is the paragraphs of the codicil that were considered to be invalid, like the primary part of the 4-page letter form codicil that the testator had written. And she had previously gone to a professional to have her will and her first codicil drafted. But a few months before she died, she prepared a 4-page letter setting out why she wouldn't want anyone to challenge her will and what she wanted to happen if they did. And these are the 2 key paragraphs. So, as a safeguard to my wishes and to protect them from any parties, be they family members or the charities, should they wish to contest or disagree with my will, then I want the following clause to override everything previously stated in my will in its entirety. This, I hope, will prevent anyone from taking this case of action. I give and devise and bequeath my beneficial share in the property known as Oakwood Farm to my beneficiaries, Sally Leonard and Paul Leonard, free of any taxes, which will be covered by my estate. I also give to the above named persons all my real and personal property. This clause cannot be superseded and will only come into being if at any time during the life of the trust or up to 80 years has elapsed. So looking at these paragraphs, the first paragraph was considered by the court to be the condition, and the second paragraph was considered the attempted gift over. And the court then had to decide if the condition was valid and also what the effect of the gift over was. So James, if you would mind popping over to the next slide. So the court, in deciding this matter, obviously looked at tests for legal certainty. And Judge Martin relied on Cook and Turner when he confirmed a condition to the effect that the beneficiary who challenges a will loses the benefits given to him by the will is, in principle, valid, at least where there is a gift over. And then he also relied on the following passage from Clayton and Rounson, which in turn quoted words from the 1859 case of Clavering and Ellison. The courts have always insisted that conditions of defeasance, in order to be valid, should be framed so that the persons affected can from the outset know with certainty the exact event on the happening of which their interests are to be divested. The principle was enunciated many years ago by Lord Cranworth in Clavering and Ellison in the following words: where a vested estate is to be defeated by a condition on a contingency that it is to happen afterwards, that condition must be such that the court can see from the beginning, precisely and distinctly, upon the happening of what event it was that the preceding vested was to determine. In all such cases, that is a test which has to be applied to the particular condition which the testator has chosen to impose. So what this effectively means is that any no contest clause needs to be really clear and certain and contain certainty as to what is going to happen to a gift if the forfeiture is triggered. Now, as Tom stated earlier, the charity was the party in the preliminary hearing who were challenging the validity of the clause, and they challenged these paragraphs on the basis of three challenges. So the first one was that it didn't specify who would trigger the forfeiture by making the challenge. It also didn't specify with the words what would be the trigger event. And there was also real difficulty with the last sentence, which stated this clause cannot be superseded and will only come into being if at any time during the life of the trust or up to 80 years has elapsed. because this sentence lacked certainty by not defining the trust, but it also appeared to miss out some words, which made it really hard for the judge to decide what it was that the testator had actually wanted, or what her intention was with this sentence. So if James, if you could pop over to the next slide, we're going to break these down. So the first bit is the bit in blue, which is the lack of certainty who would trigger. So Mind said, well, there's been no specific names mentioned as to who would trigger the forfeiture if they challenged the will. They said that the references to any parties, be they family members or the charities, and the fact that she had just said prevent anyone from taking this case of action, didn't lead to a specific person who would then be able to actually trigger the clause. However, Judge Martin did not accept this. He considered the codicil as a whole, so he took the whole 4 pages together and found that the testator's overall intention in preparing the codicil had been to provide her justifications for giving Sally and Paul Leonard the right to occupy the property and make sure that the testator's wishes were actually, in fact, carried out. And so, considering this, he found that she would have only contemplated a challenge coming from Andrew or one of her other children, Martin or Robert, or indeed the charities. So the definition of a family member or the charities was sufficient in his mind to show that, you know, those are the types of people she was expecting would to make a challenge, and they're the ones that are going to suffer. So the next challenge was the potential trigger event, and Mind argued that the condition lacked certainty because the phrase, should they wish to contest or disagree with my will, didn't give a clear trigger event, because it didn't say, well, on issue of a claim, or, you know, and Mind argued, well, is it enough that someone should just have an idea that they're not happy with a will, that they, you know, I think the phrase was secret harborings of thoughts that, like, you know, they weren't happy. And the question was, well, is that enough without actually doing anything about it? Is the trigger event writing a letter before action and then doing nothing about it, or just having thoughts, having discussions? Because the clause itself was, or the wording that the testator used was so ambiguous, they say. But the judge, again, did not agree with Mind's submissions, and he said that it was clear, again, from the whole of the codicil, that Diana's intentions was for not for the forfeiture to occur if a family member or charity simply disagreed with the gifts without saying or doing anything about it. And he further explained her objective was to deter anyone from taking steps to alter the disposition she had made. Construed in that light, the words wish to add nothing to the words contest or disagree. He also went on to say that threats would not be enough, but proceedings challenging the will on the ground of lack of capacity, want of knowledge, approval, or undue influence would be. So also would a claim under the 1975 Act, since it would have had the potential to bring about a redistribution of the estate. So then the last challenge that Mind made was in relation to this last sentence, which is there in red. This clause cannot be superseded and will only come into being if at any time during the life of the trust or up to 80 years has elapsed. And this sentence caused problems because it appears to be missing some words. It doesn't quite make sense. And also because the trust was considered as not being defined sufficiently, because throughout the hearing, they'd heard about 4 different trusts. So there was the residuary will trust, the trust created by the testator's former husband, a separate trust that the testator was considering making for Andrew, for the benefit of Andrew, and the trust relating to the jointly owned property. And in relation to the last sentence, Sally and Paul Leonard, who of course wanted the condition to be valid, argued that these words were not intended to introduce any additional requirement and were merely a statement of the obvious. But in relation to the problematic part, which was really the will only come into being if, Judge Martin found that it did imply that the gift over would only come into play if something else happened. But what that something else would be was difficult to know because it just really wasn't clear. He said, but the words "and will only come into being if" seemed to me equally capable of merely explaining something that is anyway obvious, rather as if the whole provision had been preceded by the words "of course," and of indicating that the clause will only operate if something else happens. I am unfortunately quite unable to tell which was intended. In consequence, I find it simply impossible to know whether or not Mrs. Nathan intended by these words to impose a new requirement, and if so, what it was. They went on to say, the uncertainty this produces is not confined to the gift over. It is quite possible that by this clause, Mrs. Nathan meant the whole of the condition and the substituted provisions that would come into effect if it operated. So he then found, just because of this last sentence, that there wasn't sufficient certainty to pass the test in Clayton and Ramsden, which does sort of beg the question, if the last sentence had been removed completely and it wasn't there, would this have been a different outcome? Possibly. But, you know, having this ambiguous sentence and the way that it was drafted is not particularly clear. The fact that it was 4 pages long and then really only looking at these 2 paragraphs does go to show that you really have to be careful about the wording that you're using. So what can we take away from Nathan and Leonard as to what is good drafting? Well, it does seem that you can have loose definitions of who triggers the forfeiture, but it's probably better on the safe side. And you'll find in most precedents that they do define the people who would trigger the forfeiture by reference to them being a beneficiary of the will, at least if not named. And there is an interesting point in Nathan and Leonard, is that Andrew, who was making the 1975 Act claim, he was given a third of the estate to be put on trust, but he wasn't the only beneficiary. It was, the charities, obviously, and also his issue. And by him making the challenge and the way that the condition was drafted, it did mean that the charities and his children were going to be losing out. And so you have to think about that as well. Like, you have to think about the term of the gift and how it's, how the gift is being made, to then determine, well, who is it that's within that term of class of beneficiaries is then going to trigger the event, and is it going to affect everyone? So there was that hadn't been considered at all when this was obviously drafted by the testator. The second thing to take away is that you don't also have to have a specific trigger event. But again, most modern precedents will specify, in relation to issue of particular claims or lodging a caveat and things like that, that would then trigger the challenge. And it is better to do that so you don't have this dispute over whether or not there is legal certainty there. And then the third thing is that you really have to make sure that there is absolute certainty as to what the consequence is going to be, and make sure that it's really clear and that there's no ambiguity and it's really obvious what the testator wanted to happen should someone challenge the will and give up their legacy. And then, drawing on what James referred to earlier, is that you also need to consider, when preparing these types of clauses, well, what is the deterrent that you are giving? Like, what is the gift that you are giving, and would it be a sufficient, will the amount or the gift be a sufficient deterrent for the beneficiary not to challenge the will? Like James said, £5 probably won't be a sufficient deterrent, but £100,000 could be. And I think that you also have to then consider those points when you're drafting. So it's not just about the words, it's about the whole effect as a whole. So now we are going to discuss what we consider a valid no contest clause in a case study that we've prepared. And I'm going to pass you back over to James so he can introduce the case study and the people involved.
Perfect. Thank you very much, Alex. So this is the case study. As you'll see, it's the estate of Antonia Blair and her family members, Gordon, Alistair, and Mandy. It's as Alex said, it has a no contest clause. Come on to that in a second, but just to give you the sort of outline of it, what we're going to do is I'm going to just set out the structure, or set out the parameters of it, and then for each of the three named legatees, Gordon, Alistair, and Mandy, we're each going to sort of talk about the process, whether it be advisable for them to bring a claim on the basis of the evidence we have. So, and for each one, I'll give a bit more context that's on this slide. It's just the basic outline. But in essence, you have a testatrix, Antonia Blair. She dies leaving £1 million, all of which are liquid. They pass according to her one and only will made the year before her death. That gave £300,000 to her long-standing cohabiting partner, Gordon. It gave £500,000, which effectively was a gift to her 4 grandchildren, but subject to a life interest of her son, Alistair. So Alistair is entitled to the income of that £500,000 during his lifetime, and then after it passes to his children, absolutely. And so just for the purposes of the exercise, there's no power to advance capital, so he's entitled to the income only. And £50,000 goes to her daughter Mandy, and the rest, £150,000 odd, is left to various charities. And there is a no contest clause, which in the terms set out on the slide, I won't read them out, but in essence, what they do is that if a person whose name is a beneficiary brings either challenge the will by validity claim, or challenges brings some climate claim or caveat or anything like that, any benefit they individually would have received is forfeited, and the will takes effect as if they've never received anything. It's quite different, obviously. This is taken from a standard precedent, so there's nothing particularly exciting about this draft clause. The very different nature to the one in Nathan and Leonard, because obviously in that case, effectively, if anyone brought a challenge, the whole will went out the window and a whole new will, a set of provisions were imported. That isn't the case here, and if that was the case here, sometimes you find one which said, if you challenge it, everything goes to my children in equal shares, in which case, it's not like Mandy might as well just challenge it, because the moment she challenges, she gets half the estate. It'd be madness. So this is a pretty standard phrase, but whoever challenges it loses their entitlement is the key thing to take away. So the first of these people is Gordon, and just to give you a bit more context about Gordon. So Gordon, they lived together for 25 years. That house was paid for by Antonia, so he was reliant on her for his housing. He is retired, limited income and limited assets, but in the last few months has begun cohabiting with a new partner, Keir, a very wealthy man who lives in Islington. So Tom is going to lead on this one. Tom, what do you think?
So if I were advising Gordon, the first thing to make clear is, of course, that there's no interest or there's no reason why Gordon would ever seek to challenge the will being valid, because it's, despite we don't know much about it, say for it was made 1 year before death, there may be some concerns about whether the will is valid, and there may be some grounds to look into that, but Gordon would have no reason to do so because he doesn't stand to benefit under intestacy. So we're looking solely from Gordon's perspective from a 75 Act angle. Gordon seems to be receiving 30% of the net estate, which is a pretty, it's that difficult borderline of generosity where long-term cohabitation, as a partner, he'd be eligible to bring a claim. He was clearly reliant on Antonia for his housing need and perhaps other needs given his impecunious state. However, I think given that the approach the court would take would be that if the clause is valid, which it seems to be, they would treat the first stage as Gordon receiving nothing from the estate if he were to bring a claim. And then it would be looking at what is reasonable for Gordon. There's a big risk for Gordon that he would not receive £300,000 under the Inheritance Act. And if he didn't better, the clause that he stands to benefit from in the will, he'd get significant cost exposure. The court, when looking at the factors in Section 3, would look at the legacy given to him in the will. And I think his risk is, it's too high. I may be quite risk averse, but I think that I certainly wouldn't advise Gordon to challenge this will or bring a claim against the estate. I think it's not in his interest to do so. I would take the legacy.
Yeah.
What do you think? Anything you'd add to that, or are you happy with Tom's analysis?
No, I think he's right. I think it would be very risky, and I think in this way the no contest clause is bad, is doing its job and deterring him from making any further claims. And I think he would be better off just taking the 300,000 and walking away.
I think that's right. I agree with that all. My only be contrarian, I suppose. The only argument he might have is if what Antonio was providing with him by way of housing was worth significantly excess of what he's been given, maybe a suggestion that he's entitled to a greater sum. But £300,000 is a very healthy.
If he's now moved in with Keir.
Well, that's correct.
His housing need is being met.
Yeah, those things are always interesting. I always think the sort of the new, because I think when people are reliant on others for things, you can always make the argument that that's always sort of tenuous, and all it takes is for Keir to decide that he wants to get back together with his ex Jeremy or whatever it might be, and that sort of, that ends that relationship, and it also ends all of his housing ability to house himself. But I agree, it's as at the date of any hearing, if he's still with Keir, that's going to undermine his claim for sort of housing needs. I agree. The next person who may have a claim is Alistair. So to give a bit more context on Alistair, Alistair's entitled to the income of the £500,000 only. He's a failed entrepreneur with a lot of debts. Antonio was giving him significant financial support, firstly set up those businesses, and then she helped him paying off some of those debts, but had increasingly become sick of this, and a few years before he died, she had stopped providing any more financial support. So enough's enough. The income he will receive from that £500,000, whilst it's may look like a significant amount of money, it's not going to be sufficient for him to meet the instalments on his many debts, and so they're just going to keep compounding and becoming greater and greater. I'm going to lead on this one. This is so in terms of the different challenges, I suppose the first question is, if there were grounds to challenge the will, would he be advised to do so, or would the no contest clause be a disincentive? I suppose probably it's more valuable to him than not. Obviously, depending on the prospect of success. If he succeeds on setting aside the will, then he will be entitled to half the estate, absolutely, rather than just having an interest in the income of it. That's likely to be a lot greater than what he's going to receive by way of income. So that's potentially a positive thing for him. Of course, in doing that, though, he is giving up potentially quite a significant amount of money. It's not the interest of that amount of money is probably quite a lot. We've done the calculations in terms of the interest rates and how it's invested and so on. But if he's giving that up, then he's going to be left with nothing from this estate if his claim doesn't succeed to set aside the will. That is. Of course, the other thing with it is there is a sort of moral or sort of family basis that if he does succeed in bringing that claim, that is going to significantly undermine. But it's going to mean his children receive nothing from the estate. As it stands, they're entitled to receive £500,000 absolutely upon his death. So that if he challenges the will, they're going to get nothing. So there's that kind of dynamic in there as well. Potentially puts him in conflict with them. But that may be something he doesn't care about. Who knows? Obviously, if he was going to bring that challenge the validity, he would be well advised to bring a 75 claim alongside that, because obviously if the consequence of the validity challenge failing is that he ends up with nothing, he may want to team that with a 75 claim in order to sort of protect his position a little bit, if he's going to challenge it one way or another. Would you advise him to bring a 75 claim on its own? I suppose the question really is does he stand a chance of convincing a court that what he's been given is not reasonable financial provision and he should get something better than that? I think it's not completely unarguable. You could say that there obviously was a pattern of maintenance over a long period, and significant financial assistance given to him by Antonia, albeit it came to an end before she died. I think you could argue on his behalf that what he's been given, the life interest and income, is below what's needed for his maintenance, paying off debts being an example of maintenance. So what reasonable provision for his maintenance would be to earn enough money to allow him to pay off those debts. Whilst it probably, we don't know how much the dates are, but one way it could do it is to swell the pot so he gets greater income, but that means taking away from other beneficiaries. Another way to do it would be to give him a lump sum, but that obviously then has big ramifications, because that lump sum, if that's going to be used to pay off his debts, is going to have to come from other beneficiaries, whether that's the charities and the residue, or from his own children, or from Gordon, so or for his sister for that matter. So there are quite big issues with it. There's also, I think, the point that the court might not look particularly favourably on an adult child who's received a lot of support already, and through their own bad life choices has caused themselves issues. That's kind of the Shearer and Miles point. So I think the key question is, if he brings game, is he likely to do better? Maybe in terms of getting a lump sum to pay off those debts. You sort of having a bird in the hand is better than two in the bush. I think really, if you're advising him, I think you'd say it's a pretty risky approach to take. I mean, I wouldn't necessarily think this is a good claim, nor is it one where his likelihood of doing better is going to be easy to show, and you might put yourself at cost risk as well. So it really depends on how desperately he needs that cash. If the loan sharks are there at his door and he's being sued by people left, right and centre, well, then you might take the gamble if you're him, because you're better off getting that money in so you can pay off those debts, because the life interest isn't going to do you many favours in the long run. But that is a bit of that then potentially risks upsetting your children's provision and so on. So I'd probably be advising him not to go for it unless he has some real need to do so.
Yeah.
Although on the children, one argument could be that it would be better for his children that they just got the gift and they got the trust. But on the other hand, it could be better for his children that he is able to pay off his debts and, be able to provide for them now. So it's one of those tricky things, whether or not his children would then reap the benefit of what he does or not.
I think that Gordon and Alistair examples are good examples of where these clauses can really help testators and can uphold testamentary freedom. They're really testing the appetite for risk for these potential claimants to try and better themselves at court, with the risk of quite significant risk of depriving themselves of their legacies or their interests. So yeah, I think these are two good working examples of how these clauses can really uphold testamentary freedom, and I guess serve the purpose that we're talking about today.
There was a question that's come in, which I'm just going to answer very quickly, if you don't mind, and then I'll pass on we'll talk about Mandy. We actually discussed this earlier amongst the three of us. If Alistair claims unnecessarily to his children suffer as well, does this kind of cause them to lose out? I think the answer is no, because on our clause, and just looking at that, what it says is that anyone who would otherwise benefit, but who then institutes proceedings and so on, the will to take effect as if no provision had been made to benefit that person. And so it's really aimed at just taking out their provision. So given that effectively what you have is a gift to the children, but subject to his life interest, it depends on how the gift is worded in the will, and the wording on the slide isn't particularly, I wrote this slide, but it's not particularly felicitously drafted, I think it's fair to say, but I blame only myself. If that's the case, then what would happen? Essentially, he wouldn't get his life interest, but the gift would just pass absolutely to his children. So it's not necessarily a disastrous outcome for his family, depending on who those children are, what his relationship is, and so on. Yeah,
this is why it comes back to being really careful when you're drafting the clauses to, so you don't get yourself in a Nathan and Leonard situation where you are a class of beneficiaries and one of you then makes a challenge, and that then makes it really difficult for the others. So that's why you really need to be careful with the drafting and make sure that it is specific.
The last beneficiary is Mandy, who Alex is going to lead on. Just before she does the contest, just to give you a bit of context, she's been given £50,000. That was obviously in a will made a year ago. Since that will was made, she suffered a very serious car accident, is now wheelchair bound for the rest of her life, and is going to need to spend lots of money on her care and also on paying for adaptations to her home and so on. Antonia had promised that she would pay for those adaptations, but died shortly afterwards. Alex, over to you.
So for me, this is quite a simple one. I would definitely advise her to challenge either on the basis of the will, so we'd have to make investigations and see what the validity of the will there, because obviously as a child she would inherit a lot more on doing testacy. And also in relation to the 1975 Act claim, her circumstances had changed. Her mother had made, promises to her. I think she would have a quite good success at getting, upping what she's due to get under the will, if she was to make a 1975 Act claim, because of now her, physical, medical needs. She was looking at making adaptations to her home. She's going to have a long-term effect on her. And there's probably a strong argument there that her mum would have left her more had the accident happened, more earlier, if her mother had time to change her will again. And £50,000 is probably not a sufficient amount to deter her from bringing a claim and bringing a challenge. Do you have anything else to add?
Yeah, I agree. I mean, obviously, we don't know much about the will, as we said. So, the petition on intestacy really stands to benefit Mandy too. So we'd want to know more about whether there was a will challenge there. But I do think that in the circumstances, Mandy has a good chance of bettering her legacy, such that that there's enough appetite there for a claim to be brought.
Yeah, especially considering there's 150,000 that's going to charities. That could, the charities probably won't be so happy saying this, but they could give up some of their, so she's not inhibiting her nieces and nephews and her brother.
My view is always depends on which charities. If you've got a research shot that you're generally unwilling to give it, depends on who's on the other side. I think some are more friendly towards claims than others. It's fair to say. So yeah, these three, but I think the point is that I think the summary of this scenario, and obviously Tom's going to summarize everything in a second, so still his thunder, but is that for different people these are, depends on the circumstances, but they can be quite important, as Tom said, for sort of moving the needle on risk, and certainly for the first two of those there's a sort of more of a risk, whereas for Mandy, given what's happened to her, especially since it's happened since the will was made, I think, as Alex says, she's got a pretty compelling claim. It's unlikely to deter from bringing that claim in those circumstances. Excuse me. Anyway, pass over to Tom, who's going to summarise it all.
So, in summary, some top tips on drafting, as per Alex's part of this talk. But standard no contest clauses are valid and effective if properly drafted. And if in doubt, the precedents that exist, then they are likely to be properly drafted. So it's only in circumstances like in Nathan Leonard, when she handwrote her own codicil, whereby that gave rise to these concerns. So standard clauses are valid and are effective to be used and deployed effectively where appropriate. But be careful about the wording. They must have valid gift over and specify what's to happen to the fund if the legatee forfeits their entitlement. It is possible, as per Nathan Leonard, for the no contest clauses to specify that not only the claimant, but also other beneficiaries lose their legacies as a result of a claim. In those circumstances, the innocent parties, so to speak, can apply for relief from forfeiture. But that will be dealt with, depending on the wording of the clause and on a case-by-case basis, and unfortunately hasn't been tested really in any subsequent judgment. The trigger event for a clause, unless it expressly specifies otherwise, will be the actual issue of proceedings. So the issue of a claim under the Inheritance Act. It won't be typically a letter before action. So if you are advising a client in circumstances where they think, is it worth testing the water with a pre-action protocol letter, that won't be likely to trigger the clause itself. It's more likely to be at the time of issue of proceedings. And so there's probably room for some sort of gauging of the other side's position in the first instance. But in summary, I think these clauses are unlikely to deter a strong claimant under the Inheritance Act. If you've got a long-standing, a long marriage spousal claim, I don't think they'd have much effect. But they are a useful tool to deter borderline claims and really testing the claimant's appetite for risk. And the examples of Gordon and of Alistair are really good examples of where the testator's intentions and their wish for ultimate provision from their estate, really, with the inclusion of that clause, can sort of prevent or deter Gordon and Alistair from bringing a claim. And you think about cases like Ilos and Mitson, and you think, well, if there was provision made in the original in the will for a modest legacy and a no contest clause, it could have avoided potentially a claim being brought and lots of costly and hostile litigation ensuing over the years. So I think they do serve a purpose. I think, why would you not include them? If you want to carry out your effect, obviously the caveat being strong claims such as spousal claims probably will bypass them quite easily. But with cohabiting partners or adult children, I think they have a real purpose.
We're going to drain the swamp of these bad 75 Act claims. That's the aim. We've got a couple of minutes. People have questions. I've been answering the Q&A as we've gone along. The one question sort of outstanding which is from an anonymous attendee, which I enjoy. It says, it may require a whole other seminar, but could you comment on no contest clauses in trusts as opposed to in wills? I don't know if anyone wants to weigh in on that before I put my hands. We've got a couple of minutes. I mean, I think it is a whole other seminar. It's a different topic, but it's obviously related. But it does call off conversation itself.
I would defer to you, James, on that one.
No, I agree. It would be.
Yeah, I mean, I think the principles are a million miles different in terms of repugnancy and so on. I mean, some of the cases that Alex was citing earlier actually are trust cases rather than
that's right. A lot of the case law goes back quite a long time. In fact, so a lot of the cases do refer to trusts, and so the principles are the same, but in practice I haven't really come across them much, so I wouldn't want to comment too much on whether or not there's massive difference in the practicalities of how they're applied now.
Yeah, it's quite. It's quite a broad question, but if there are any particular questions you had about them, feel free to fire them over. But I mean, that's our general commentary. Good. It's now 27 past, so got a couple of minutes. People want to ask any questions.
If you do have any questions that come to mind after this talk, you can please pop either myself, James, or Alex an email. Our details, there we are.
Yeah, there we go. Let's go to Edward Stanley. As with all wills, is it useful to regularly review the no contest clause to make sure the value of the gift is proportionate to the value of the estate as a whole? I mean, I think the answer is yes to that. I mean, the Mandy example is a good example of that. It may have been proportional, or it may have been an appropriate provision at the time, but obviously by the time she died, things had changed quite significantly, and it became probably unreasonable in terms of financial provision. So I think that's right. You would review. I suppose you review the no contest clause, but really the clause may still be fine. It's maybe the effect of that clause, given whether the clause is going to remain a suitable deterrent, and that's going to be looking at what's being given to people rather than what the terms of the clause are. Because I think if you use the terms of the clause we had in our example, which are taken from a standard precedent, there's nothing particularly, there's nothing there that require enormous amounts of updating probably. If you were going to have a Nathan and Leonard type clause, which completely deleted the will and set up a whole new set of provisions, then yes, you'd certainly want to be looking at that quite carefully all the time, because that's going to, whether that's an appropriate revision is going to, whether that's going to actually fulfill the testator's intentions as things move on, it's going to need to be reviewed.
Yeah.
There's a question about partition, which I've answered already. I think that's just a follow-up to that. You have our email addresses, so if anyone wants to get in touch with us, you're very welcome to send us any questions you have afterwards. We'll defer all of them onto Tom to answer. But thank you very much for joining us today. It's been a pleasure joining you. Thanks to TL4 for having us, and for Howard Kenty for inviting me on to join you.
Thanks very much.
Thanks,
everyone.
Thank you.
Thank you.